Well, thank you very much. Thank you all for coming to this press conference by the Special Rapporteur on the Promotion and Protection of Human Rights and Fundamental Freedoms while Countering Terrorism, Ms. Fionnuala Ní Aoláin, following the conclusion of her technical visit to the United States and the detention facility at the U.S. Naval Station Guantánamo Bay, Cuba. The special rapporteurs, as you know, are independent experts who are appointed by the Human Rights Council. They are part of what is known as the Council's Special Procedures, which is the largest body of independent experts in the UN human rights system. Ms. Fionnuala will deliver opening remarks, and then she will take your questions. You have the floor. Thank you.
Good afternoon, everyone. Today, as Special Rapporteur on the Promotion and Protection of Human Rights and Fundamental Freedoms while Countering Terrorism, I welcome the completion of my technical visit to the United States and to the detention facility at the U.S. Naval Base at Guantanamo Bay, Cuba. This visit marks the first official visit by a UN expert to the site. In allowing an independent United Nations human rights expert to undertake this visit, the US government has led by example, by being prepared to address the hardest human rights issues. As I open this press conference, I wish to affirm the openness of the technical visit, the spirit of positive, constructive dialogue that sustained it, and the singular importance of access to all sites of detention, which the United States government has recognized by enabling this visit. I was given access to all that I asked for, consistent with the rigorous terms of reference for country visits by United Nations Special Procedure mandate holders. My visit comprised of 3 parts, and the report issued today addresses all 3 of them. The first is the rights of the victims of the 9/11 terrorist attacks. The second, the rights of detainees at the Guantanamo Bay detention facility. And the third, the rights of former detainees who have been resettled or repatriated. My technical visit months ago started with a visit to the 9/11 Memorial and Museum and was deeply engaged with the victims, survivors, and families of the terrorist attack throughout. I find unequivocally that the 9/11 terrorist attacks constituted a crime against humanity. In my many, many meetings with victims and survivors, the devastating long-term consequences of 9/11 for individuals, for families and communities was evident and is still painfully present. My report makes clear findings regarding the gendered and generational consequences of the attacks. I want to express my very particular concern for child victims of 9/11 and the waiver of their rights to legal remedies, including litigation, by family members in the aftermath of 9/11 when they had limited capacity to meaningfully waive their rights as they were managing profound grief, trauma, and loss, and extraordinary burdens of care. While I commend in this report the extensive legislative, social, symbolic, and financial action taken to support the victims of 9/11, more needs to be done to fill significant gaps in realizing their rights to reparation, including long-term comprehensive legislative provision to ensure the long-term security and reliability of compensation and medical entitlement without discrimination for all victims and survivors. I make a number of recommendations, but I'll just highlight a few for you here. The first is for the US government to initiate a comprehensive audit of existing medical support, both physical and psychological, for victims and survivors. That assessment should be human rights compliant, it should be comprehensive, and it has to be victim focused. I also call for enhancing existing communications and access to information for victims and for families, including in ongoing litigation and the military commissions through the Department of Defense's Witnesses Victims Assistance Program. And finally, the report asks for advanced comprehensive federal legislation to protect the human rights of all victims of terrorism in all dimensions. One thing that's clear, this report upholds the rights of victims of terrorism to justice, to accountability, and to transparency. But I find that the single most significant barrier to fulfilling the rights of victims and survivors was the use of torture. Torture was a betrayal of the rights of the victims of the 9/11 attacks. The US government must urgently provide judicial resolution, apology, and guarantees of non-repetition. Let me come to part 2 of my visit. During my site visit to the Guantanamo Bay detention facility, I received all requested access to former and current detention facilities and to detainees, including high-value and non-high-value detainees, as well as military and civilian personnel. In addition to that, I met at Guantanamo Bay and in Washington, D.C. and New York with U.S. government stakeholders, with military commissions personnel, with defense lawyers, with human rights and humanitarian organizations. I want to acknowledge that there has been significant improvements made to the conditions of confinement at the Guantanamo Bay detention facility. That said, I still have serious concerns about the continued detention of now 30 men still there, and the persistent arbitrariness that pervades their day-to-day existence. My report details structural shortcomings and systematic arbitrariness, including in training, operating procedures, and the fulfillment of detainees' rights to health care, family counsel, and to justice. The report sets out in detail how such arbitrariness brings about deep insecurity, suffering, and anxiety to all detainees without exception. I observe that after 2 decades of custody, the suffering of those detained is profound and it's ongoing. Every single detainee I met with lives with the unrelenting harms that follow from systematic practices of rendition, torture, and arbitrary detention. As I listened in those conversations, I understood that for many of these detainees, the dividing line between the past and the present is exceptionally thin. For some, it's simply non-existent. And their past experiences of torture live with them in the present, without any obvious end in sight, including because they have not received any adequate torture rehabilitation to date. I confirm in this report the depth and severity of many detainees' current physical and psychological harms. And I find that despite the evident nature of those harms, the Guantanamo Bay detention infrastructure entails near constant surveillance, forced cell extractions, undue use of restraints, and other arbitrary and human rights non-compliant implementation of the standard operating procedures which stem from inadequate training, structural and entrenched physical and mental health care deficits, inadequate access to family, including the failure to facilitate meaningful familial calls and visits, and ongoing arbitrary detention, which is characterized by sustained fair trial and due process violations. The totality of all of these practices and omissions detailed at length in the report have, among others, they have a cumulative compounding effect on the dignity and fundamental rights and freedoms of each detainee, and amounts, in my assessment, to ongoing cruel, inhuman, and degrading treatment under international law. I also make recommendations in respect of the detention facility. First, to conduct a comprehensive review of the standard operating procedures on their face and in their implementation for human rights compliance, including with a view to mitigating re-traumatization in consultation with independent medical experts. I also call for a guarantee of torture rehabilitation and the treatment of health concerns relating to torture and ill treatment, aging, disabilities, and other conditions, including through prompt, unconditional, confidential, and comprehensive access to health care. Thirdly, I call for an equalization and improvement of the frequency and quality of family communication to ensure simply that it is meaningful and that all detainees, regardless of their categorization, are provided with at least one call per month, recognizing the long-term impacts of prolonged periods of isolation on this population. Finally, in this regard, I call for the guarantee of equal access to counsel to all detainees, regardless of their categorization, and to unequivocally safeguard the prohibition on torture-derived evidence in all proceedings forthwith. Finally, let me get to part 3 of the report, a long report, as those of you who've already downloaded it or have it here in your hands with you. A central part of this visit for my team and I was that we met with a representative group of repatriated and resettled detainees across regions and their families, as well as government personnel and other relevant stakeholders in third countries. I identify serious shortcomings in the provision of the essential means these men need to live a dignified life, including a lack of legal identity, the lack of adequate physical and mental health care, including torture rehabilitation, education and training for them to undertake meaningful work, culturally and socially appropriate housing, and a right for these men too to have access to family life, including reunification, and for many of them, the right to freedom of movement. So I am profoundly concerned that the vast majority of former detainees continue to experience sustained human rights violations, beginning from the very process of transfer to their country of return or their country of resettlement. Mostly, they have been left to fend for themselves. I have witnessed firsthand their vulnerability to penury, to social exclusion, to stigma, and to sustained government interferences. This continuing stigma in particular, experienced by former detainees, even as they try to rebuild their lives with dignity, is striking. And so despite the discrete and concrete international law obligations of the United States which are engaged before, during, and after the transfer of detainees, there does not, in my view, appear to be any adequate system in place by the US government to address the well-being of those transferred, or the failure of the receiving government to respect the rights of those transferred once they're in another country or their home country. These obligations that I name are the obligations of a more specific and compelling form when the individual who's transferred has been tortured in the custody of the state and requires a guarantee of adequate torture rehabilitation. So here again, I have multiple recommendations in the report, but let me simply highlight a few. First, to formalize the informed consent process for detainee transfers, to stipulate that at a minimum, sharing a comprehensive and transparent overview to the detainee who's being transferred of the proposed conditions and potential legal identification, stigma, and reintegration challenges that they may encounter, as well as a clear procedure should the detainee refuse to be transferred. Second, we need to provide effective oversight of diplomatic assurances and the broader repatriation and resettlement efforts or practices for both current and former detainees to ensure that they are human rights compliant. Thirdly, we need to remove former detainees from watch lists. And finally, I call on the US government to provide effective remedies and redress for these men, including fair and adequate compensation, and as full a rehabilitation for torture as is possible for those who were previously detained at Guantanamo, which is a direct correlation to the obligation to prevent and remedy torture. So let me conclude. It's a long statement, I know, but this is a long report, and it has 3 important, equally weighted components. I want to conclude by stressing that the US government must ensure accountability for all violations of international law, both for victims of its counterterrorism practices, present and former detainees, and victims of terrorism. I underscore the importance of apology, full remedy, reparation, and guarantees of non-repetition to all victims, and these guarantees will be no less pressing in the years ahead. In many ways, this technical visit really marks the potential start of a new chapter. I recognize the enormous importance of the visit and the consequence it brings to the global elimination of the use of extraordinary rendition, torture, cruel, inhuman, and degrading treatment, as well as arbitrary detention, with the recognition that these acts have no place in a rule of law-based society. I welcome the openness and the willingness of the US government to lead by example and to be prepared to address simply the hardest of human rights issues. Few states exhibit that kind of courage. I affirm the US government's positive role in advancing the protection of human rights in detention contexts globally by enabling this visit. So I want to close by first of all thanking my team who supported me as I undertook this visit, but also finally to thank those, including the victims and survivors of terrorism, current and former detainees, their family members and their counsel, as well as the many government officials who enabled and supported this visit. I will be very happy to take your questions. Thanks.
Many thanks, Fionnuala, for your remarks. The Special Rapporteur's report and press release should be on your inboxes. Edie, please go ahead.
Thank you very much. On behalf of the United Nations Correspondents Association, thank you for doing this briefing. I think none of us knew that you were even going to Guantanamo. So we appreciate it. My name is Edith Lederer from the Associated Press. I assume that you submitted this report to the U.S. government before it was released. Did you get a response on the many recommendations that you have made? And secondly, in talking to the detainees, especially the long-term detainees, I wanted to ask about one specific case that's been in the news. Did you get the feeling that there was any breakthrough on a plea deal for the alleged USS coal bomber Abd al-Nashiri? And given the strong evidence that torture influenced his statements, do human rights concerns obligate the United States to stop taking him to trial? Thank you.
Great, thank you for those two questions. Let me start by acknowledging that, as with any country visit, the regular process for special procedure mandate holders, the government in question does get a copy of the report in advance and is allowed to correct or identify any issues that of factual error that arise in the report. That standard procedure was fully undertaken in this report context. And I'm also pleased to note that the US government has issued a response to this report, which should be available on the website of the Special Rapporteur with the report's publication. I welcome that response and acknowledge overall, again, the transparency and positive interaction in relation to this visit. I also acknowledge that the US government has said it will regard the recommendations set out in this report seriously and thoroughly. And I would say that special rapporteurs, when they give advice, can ask for no more than the government taking them on board, and we certainly hope they will in this case. As to your second question, let me just say in relation to the detainees I met with, as you know, at the very beginning, I indicated in my press statement that I met with both high-value and non-high-value detainees, and they were a representative cross-section of detainees. One of the things I made clear to the US government, to the detainees themselves and to their counsel when I undertook this visit, that I would fully abide by the do no harm principle for the detainees. And consistent with all of my country visits, I will not disclose whom I met with, and I won't reveal any identifying information of current or former detainees. except insofar as there are individual cases that the mandate has dealt with that are already in the public domain. And what I would say is that that's important for a number of the reasons. One is because many of these men, as I've detailed in the report, continue to experience deep and profound suffering. And the risk of harm to them, including from my report, is significant. I also want to acknowledge that many of these men's families are also at continued risk. And so I won't comment on individual cases. What I can say in relation to the question of torture evidence, and I've addressed it before, is that consistent with the US's obligations under international law, we make clear, and we've welcomed previous statements by this administration, that there won't be use of torture-derived evidence. The report makes clear that any torture-derived evidence use would simply be inconsistent with the US's obligations under international law. Go.
Yvonne? Yeah, go ahead.
Thank you very much. Yvonne Murray, RTE News, Ireland's national broadcaster. So on the first page of your report, it says that you were told with great regret that you had arrived too late at Guantanamo Bay. Why did it take so long for you and your team to be granted access? That's my first question. My second question is, for a lot of my audience, they find it hard to understand why Guantanamo just simply cannot be closed. Could you explain why? There are 30 men, I understand, still there. What are the barriers to them going home, and why can it not just be closed down? And then thirdly, on your the response from the US government, did they address your point about the use of torture being a betrayal of the rights of the victims of 9/11? Thank you.
Thank you, Yvonne. That's really happy to answer those questions. So I think my statement at the beginning of too long was really a direct response of very heartfelt response by many detainees from seeing a person who was neither their lawyer nor one of the people responsible for them, many for the first time in 20 years. My team and I prepared with great caution and sensitivity in undertaking this visit, because we understood that in undertaking the visit itself and in meeting with detainees, that we had an obligation of care to them. I think, as many will know, the United Nations' previous UN Special Rapporteurs under different administrations had sought to get access to this detention facility, and no other US administration gave access to the detention facility. It is this administration who, early on in my tenure, through a process of discussion and engagement, enabled the visit. And so I think this is the point, that it is the very first administration to allow access. That said, there are a much smaller number of men at the detention facility now than there were years past when other UN Special Rapporteurs or UN human rights experts sought access. But I think what I would say is that what drove this visit is the commitment to the principle of access to places of detention, no matter where they are and who is in them and what their status is. And the redemption of that principle of access, notwithstanding that there were a much smaller number of detainees there now than there were previously, is still enormously important as a matter of international law and as a matter of setting a standard in saying places of detention are not no-go areas for human rights, and we hold ourselves, rule of law abiding states, hold themselves accountable to the process of scrutiny, no matter how painful and how difficult it can be. Let me turn to your question on closure, Yvonne. So you'll note rightly that the report calls for the closure of the detention facility, and many listeners in many parts of the world won't understand why it's not closed. And I think closure remains a priority. But I also recognize that there are complexities and political challenges ahead in closing this detention facility. And I think, as the report makes clear, there are paths forward, including, as identified in this report, if the United States considered scoping transfers to U.S. military bases abroad or arrangements with foreign jurisdictions. But again, those would absolutely have to be in compliance with international law and calibrated to minimize re-traumatization for a highly traumatized, highly vulnerable population, and the triggering quality that movement would bring. But even as we talk about closure, and I do hope we are on a path to de-exceptionalization and to closure, I think that doesn't mean that we can't act, the US must act responsibly and urgently to address the current situation, conditions of confinement. This report is very clear on its finding. It's also very clear on the obligations and the recommendations made. And many of these things are imminently doable, meaning those of you, when you have time to read the report, will note that it is an imminently practical report, focused on the specificity of what can be done now to ensure that these men do not continue to find themselves in a context where they experience cruel, inhuman, and degrading treatment under international law. Thanks.
Thank you. Do we have Efrain? Go ahead.
Oh, yes.
Thank you, Laura. Ms. Ní Aoláin, very good to see you. My questions have broadly been asked by my colleagues, but I have just one quick, more general question. The Guantanamo Bay facilities have always been used around the world against the United States. Whenever the United States calls out the government for prison torture, for all those things, they use Guantanamo as, you know, the dark spot on the U.S. So how much do you think maintaining those facilities affect the credibility of the United States when it champions human rights issues around the world? Afram Kosaifi from Arab News Daily.
Arab News, thank you. So I think it's fair to say, and we recognize both for the men who have left Guantanamo Bay, Cuba, the men who have returned or been transferred to countries of origin or countries of resettlement, Guantanamo Bay remains a place of stigma, both individually but also collectively. That is clear. However, one of the things I would say is that this report is clearly a commitment to de-exceptionalize and de-stigmatize and normalize Guantanamo. And I welcome that. I welcome that because it matters that states take responsibility for their serious violations of international law. It matters that UN special experts, human rights experts, have access to even the most high secure places. Those are the kinds of places that I consistently visit as Special Rapporteur on Counterterrorism and Human Rights. If one state creates an exceptional zone, then every state can create an exceptional zone. And the fundamental point of this visit is de-exceptionalization. But let me also be clear. A visit is not it doesn't take away from the ongoing responsibilities. In having allowed my team and I to visit this detention facility, we have scrutinized every aspect of the detention facility, from the standard operating procedures to the use of numbers rather than names for the men who are detained there, from shackling to forced cell extractions, to the quality of medical care, to the absence of holistic torture rehabilitation, to lack of access to family and differential treatment in relation to counsel. These are all serious matters that the US has now a set of practical recommendations in its hands to remedy those things. And I strongly encourage their adoption. I would also say to other member states, for states who do not allow access to other sites of detention, the precedent of non-access to Guantanamo has now been broken, so other states should expect that UN human rights experts would rightly have access to other places of detention.
Go ahead, Edie, and then you. Go ahead, Edie.
Thank you. A follow-up on de-exceptionalization. On a place that is in the world's knowledge for many, many decades, how can you possibly de-exceptionalize it in a global population that equates Guantanamo with prisoners from 9/11 and all of the ramifications afterwards? And in your briefing, you mentioned aging. Is the U.S. doing enough to handle the long-term needs of all the detainees who are aging in place and may never leave Guantanamo?
Sure. So maybe just to say, de-exceptionalizing is really hard. I and others wouldn't underestimate. In many ways, the name may always be synonymous with the systematic use of rendition, torture, and arbitrary detention. But this is why I think it matters that states open up their practices to review. That it may never be perfect, but it is also a seriously significant move to accept responsibility for the exceptionalization and seek to undo it. And so I acknowledge it's not a special rapporteur's place to say that there won't always be an exceptionality associated with the terminology and the name of Guantanamo. But equally, this is an object lesson for member states in undoing. And the undoing lies both in the access and the fullness of the access and the ability to allow critical scrutiny. This is a critical report. And a democratic state committed to the rule of law is open to that kind of criticism. But the test now will be the response to the report. The test will be the implementation of the specific recommendations on all of the axes that I have mentioned. And to go back to an earlier question that Yvonne asked me, which I think is linked, which is this point about an understanding that the harm of torture didn't just harm these men and harmed them egregiously, but that it also did harm to the victims of terrorism. And that perhaps is one of the most singular findings of this report, to connect those two things, to say to victims of terrorism, the remedy that you have available now is limited and compromised and not as adequate as it should be because of the methods and means of torture that were used against these individuals. And that is an enormous both legal and moral burden for any country to carry. And it is one, given the enormous symbolic, emotional commitment to the victims of 9/11, that requires recognition. If a special rapporteur can have that conversation with victims of terrorism, that painful and difficult conversation, so too can the US government.
Just a quick follow-up. You mentioned other countries should open their detention facilities as well. Are you willing to name some of those countries? And do you believe that you'll be able to go back to Guantanamo again?
So thank you for that. And maybe before I answer that question, I'm going to return to your earlier question, which was about this aging population. It was one of the things I forgot to mention. I want to just, for those of you following online and looking at the report, I want to particularly take you to paragraphs 20 to 26 of the report, which outlines in detail the medical condition of these men and their medical needs. This is an aging population. It's an aging, vulnerable population. It is a population that requires specialist health care. It is a population that requires a recognition that past trauma must be integrated into their current medical treatment. It is a population which has an enormous trust deficit with its medical providers, precisely because they wear a uniform and precisely because many of them were harmed before by persons wearing the same uniform. It is a population which needs trust building and a feeling of control in their lives if they are to recover both psychologically and somatically from the harms of torture. And to do that, they need comprehensive, holistic torture rehabilitation. I want to acknowledge that the United States is one of the leaders in torture rehabilitation globally. It is one of the most significant contributors to the UN Voluntary Trust Fund for Victims of Torture. The US understands what's needed to rehabilitate torture victims. That knowledge and that capacity must now be directed to these torture victims. To do that, we will need not just appropriate torture rehabilitation, but independence of medical and clinical care to rebuild the bonds of trust for individuals who have entirely shattered bonds because of the nature of their previous torture. So it's in that regard that the report makes really clear that independent medical treatment for these men is essential. To your question as to other countries, this isn't a report about other countries, but I would recommend that you look at my previous Human Rights Council reports, where I have called on a number of countries who have significant arbitrary detention practices to allow access to those places of detention. So this is not the first time, and it won't be the last time, that this mandate will be calling for access to those sites. Thanks.
Go ahead.
Thank you for having this press conference. Frank Uciardo for TRT World. You were saying that you talked to some of the 9/11 victims' families?
Yes, we met with many of them.
Did they tell you they wanted this place closed?
So let me
I
just
have a follow-up.
Yeah. So it's a really good question, and I thank you for asking it. It's a good reminder. I'm really conscious that many of the questions on this report will focus on the detention facility. But this is a report in 3 parts, and each one of those constituent parts is as important to me personally and to my team as the other. I think those of you who know or have any inkling of the 9/11 family know that it is a wide and disparate family. There isn't one view in that family about both the past or the present. One of the things that I note very clearly in the report, and I say this, I suppose, acknowledging that there are those in the 9/11 family who wish the detention facility to close. There are those in the 9/11 family who wish it to remain open and wish for trials to continue. There are those who have strong views on the death penalty both ways. So there isn't a single, in my view, as I've understood in the many conversations we've had with family, victim and survivor family members over the past months, there isn't a singular view. But what the report does call for is an honest, transparent, and complete conversation with victim family members, not a selective one. We are where we are, and that has enormous practical consequences for the rights that I identify in this report, to victim families' rights to rehabilitation themselves for the harms, for ongoing psychological and medical support, for accountability. Where we are now affects all of them. And the report makes very clear that they are entitled to full and transparent engagement around all of those issues, no matter how painful they may be.
The United States got away with torture?
So I'm very clear in this regard, is that torture is a crime it's a jus cogens norm. It's one of the, meaning that it's a norm that can't be broken, even under the laws of war, not just human rights law. Torture is an absolute prohibition in international law. There is no statute of limitations for torture, as I make clear in this report. And anyone who undertook it, facilitated it, legally authorized it, hid it, sustained it, remains liable for torture. And so I don't see an end road on that conversation. And I make clear in this report that the US government remains and continues to have obligations of accountability for torture.
Well, based on what you just said, what is your opinion that a former witness to torture, for the presidency of the United States may actually get into the White House, who was there for many years.
Thank you. Good question. But it is not the job of a special rapporteur, even one who has visited this detention facility, to comment on U.S. politics. And I will defer from answering that question. But what I will say to you is, again, it's the same. Torture has no statute of limitations. And it's one of the crimes that has this persistent capacity to be what we might call sticky, meaning those who've perpetrated it, engaged in it, concealed it, authorized it, remain liable for the entirety of their lives. I would also say, though, one of the things that the report makes clear, other than that point, is that the US government has a really important role to play in the preservation of evidence of torture. And that's not simply about not allowing coercive statements to go into process, but there is an entire portion of this report focused on the preservation of evidence, including of the sites of torture, black sites, both at Guantanamo Bay, Cuba, and in other black sites, to preserve that capacity for torture to be prosecuted. Paragraph 51.
Just a quick follow-up, Ms. Ní Aoláin. Can you talk just a little bit more about how exactly torture in Guantanamo harms victims of 9/11, just to make sure I understand correctly? Thank you.
So one of the things that I make clear is that under international law, victims have a right, when there's a harm, there's a right to a remedy. And a victim of terrorism has a right to a remedy, which includes not just that they get medical or psychological treatment, but they also have a right to accountability and prosecution in relation to harms that occurred to them if there is sufficient evidence. But when you torture people, you take away the possibility of that right. So in fact, one of the things that has really profoundly struck, was clear to my team and I as we undertook this visit, that one of the things we have failed to fully articulate, but is articulated in this report, is that torture was a betrayal of the victims of 9/11. It limited their capacity to have trial. It limited their capacity to have legal proceedings. And that's evident already. We've been in pre-trial proceedings in various trials for now almost a decade. And of course, if we name significantly what's preventing legal proceeding, it is the fact of torture. So I particularly want to weigh on, not just for victims, but for the political community as a whole, to understand that the cost of torture is an annihilation of the rights of the victims of terrorism. And those who perpetrate it must live with the moral cost and the moral harm that they have perpetrated, particularly on the victims of torture. Start there. The breaking of the human body in a way absolutely physically and emotionally and psychologically. But also to understand that the harm in this case reaches far beyond that and also extends to the victims of terrorism.
I think Yvonne has a follow-up.
Thank you. I'm following up the points you made about the need for the preservation of records with regard to torture. Can we take it that you believe that there is a concern that some of the records have not been preserved or may not be preserved? And a last question, this is a very different context we're speaking in today than the one in the aftermath of 9/11. At the time, Guantanamo was justified on the basis that it would prevent terrorist attacks and it would save lives. Is there any evidence that you've seen that would justify that point of view?
No, thanks, Yvonne. It's a really good question. So I'm going to, for those of you searching through a very long report, I'm going to send you to paragraph 51. So one of the things that during the course of my visit, I had, as I said already, I had all the requested access that I asked for to previous and current detention sites, which include Camp X-Ray, Camp Iguana, now dismantled, Echo 1, Echo 2, Delta Camps 1 to 4, Camps 5, 6, and Camp 7. That's set out in paragraph 16. And so as I reviewed with my team as we addressed those sites, we understood that we felt it was really important to underscore the importance of preservation and access to those sites. It states the obvious to say that in an island where there are extremes of temperature, unless those sites are adequately preserved, they will not survive. And I was particularly concerned that without prompt material preservation of those sites, that there would be an inability to credibly establish facts, to identify those responsible for torture or other grievous harms, to prosecute, and to undertake measures of repair, redress, and protection to victims of torture. So that's particularly what I'm concerned about, having had. Just because of the weather? Not only, yes, weather, non-preservation, it's high temperatures, access to the ocean. Some of them are in places where they simply, without significant preservation, will not survive. And I take the view in this report that material preservation is particularly important to the capacity for prosecution. And also, I think many of us understand the important symbolic significance in the long term of maintaining and preserving sites for the future. And your second question was around? Yes, save lives. So it's not the job of a special rapporteur to be a clairvoyant. I can say that, but I will say that and this is not to this report, but it is my broader work as UN Special Rapporteur on counterterrorism and human rights to point out consistently to states that breaching fundamental human rights does not make us safer. It has never made us more secure. And consistent violations, including torture or rendition, create, in my view, the conditions conducive to further violence. And what I would say is that what we have seen since 9/11 is the perpetuation of human rights-free counterterrorism. We have seen the growth of counterterrorism in a way that treats human rights as irrelevant or unnecessary. And the cost of that in many places around the globe has been to perpetuate and continue the conditions, the push and pull factors that continue to engage people in violence, whether that's armed conflict or terrorism or violent extremism. And so I wouldn't say those measures did anything at all, but rather weaken the human rights protections to which every individual is due. And when you have, as the report points out, a singular population of Muslim men subject to these kinds of egregious harm, the long-term consequences for those push and pull factors have, in my view, been considerable.
Thank you. I think we need to wrap up because you have other engagement. Thank you so much for your presence. I don't see any questions online, so thank you.
Thank you.